Hello, dear friends. In the 11th lecture, I will continue the explication of the Article 10 on the dissolution of a religious legal person contained in the law number 4301 of 2014. In the second verset of the first paragraph of the Article 10, it is stated that the religious legal person can be dissolved by decision of the first instance court if its dissolution is requested by its administration for any reason, and if it is requested by its surveillance authority or the prosecutor in the following cases. So, we see that the religious legal person can be dissolved by the court in two general cases. First general case, if the administration requires it for any reason. Second general case, if the surveillance authority or the prosecutor requires the dissolution only in the following cases, specified cases. First, if it has no religious minister for over 6 months. This disposition is contrary to the Constitution and the national law on human rights standards for the reasons explained many times in our prior lectures. Because not all the religions have religious ministers. And the term religious minister is not required for a legal definition of religion. Consequently, the dissolution by the court after a request by the surveillance authority or by the prosecutor if it has no religious minister for over 6 months is an excessive case for dissolution of a religious legal person. And for that reason, it is contrary, it's against constitutional and international religious manifestation and in conjunction with religious association. Second specified reason for which the court can dissolve a religious legal person after a request by the surveillance authority or the prosecutor, if it pursues a purpose different that what is defined by law. This reason is provided also for the common associations. And the third reason, if it operates illegally or offends public order or the public morals. The first part of the third reason, it appears to be problematic because if it operates illegally, I could say that this expression is a general one. And because it's a general one, and because the reasons for the dissolution of the religious legal person must be extremely specified, because an obligatory dissolution is a very important burden imposed on a religious legal person against its will. I think that this part, if it operates illegally, is against constitutional and international law of religious manifestation and religious association, which impose on the state the obligation not to dissolve religious legal persons without grave and concrete reasons, not general reasons. The other part, that if it offends public order or public morals, is valid also for the common associations. Because the first part of the third reason, if it operates illegally, is general, for that reason, the legislator had a need to formulate the second paragraph, which disposes that the surveillance authority can carry out regular or exceptional controls to verify the lawful operation of the religious legal person, exclusively to find out if the reasons for its dissolution exist. What I have said about the generality and the compatibility of the generality to the international and constitutional standards of religious human rights is valid also for the second paragraph, which is connected with the first part of the third reason explained already. Article 11. Suspension of operation of a religious legal person. In exceptional cases, I read, and only in cases where reasons apply for the dissolution of the religious legal person or a risk of public disturbance, at the request of the surveillance authority or the prosecutor of first instance court, the religious legal person may stop operating. Its establishments may be sealed provisionally, and interim measures may be taken by decision of first instance court of its seat, which has jurisdiction to give judgment pursuant to Articles 682 Civil Procedure Code. The validity of the judgment cannot exceed a period of 6 months, whereas the provisions of Article 693C of Civil Procedures Code shall not apply. In case of existing reasons for the dissolution of the legal person, the surveillance authority or the prosecutor have to file without delay the relevant request for its dissolution, which is determined and discussed within the duration of suspension. This Article 11 concerns the suspension of operation of a religious legal person as a measure before proceeding to the dissolution of the same religious legal person. For the suspension of operation of a religious legal person, the court of the first instance is competent. The request is submitted by the surveillance authority or the prosecutor of first instance court. The reasons for which a suspension of operation of a religious legal person can be imposed are the cases for the dissolution of the religious legal person. First case. And second case, a risk of public disturbance. Then, the Article 11 gives the content of the judgment in the case in which a request for suspension of operation of a religious legal person is accepted by the court. First, the religious legal person may stop operating. Second, its establishment may be sealed provisionally. Third, interim measures may be taken. The period of the validity of the judgment is determined in the second verset of the Article 11. And the maximum period is that of 6 months. despite the fact that a suspension of operation of a religious legal person has been imposed by a court decision, court judgment. The reasons for the resolution of the religious legal person exist. Then the surveillance authority or the prosecutor have the right or better, they have the obligation without delay to submit a request to the competent authority for the dissolution of that religious legal person. But it is problematic what is determined in the end of this Article 11. And it concerns the discussion of the application of the surveillance authority or the prosecution for the dissolution of the religious legal person. That is, in the third verset of the Article 11, it is stated that this application for dissolution of the religious legal person submitted by the surveillance authority or the prosecutor has to be discussed in court within the duration of suspension. But in this case, the religious legal person has not the necessary time to correct the things and to make disappear the reasons for its dissolution in the period of 6 months. Because if the reasons for dissolution exist, the surveillance authority or the prosecutor have the right to submit an application for its dissolution, which application has to be discussed within the duration of suspension. For that reason, there is an incompatibility of this disposition concerning the discussion of the application of the surveillance authority or the prosecutor for the dissolution of the religious legal person within the duration of suspension, because in this way there is not a respect to the principle of proportionality, because the dissolution is a grave, important burden on the religious legal person, and the measures before dissolution must be proportional. That is, the religious legal person must have a full period of 6 months to correct the things which has to be corrected in order to do disappear the reasons for its dissolution. And now we pass to the Article 12. Ecclesiastical legal person. We read in the paragraph 1, a church is the association of at least 3 religious legal persons of the same religion, with episcopal or council structure, or any other central structure. It operates upon its statutes and is administered by elected or appointed individual or collective bodies. To acquire legal personality and to be registered in the special register, a joint request of the religious legal persons must be filed in the first instance court of the seat of the church. The instrument of incorporation, its statute, the confession of faith of the 3 religious persons, and the names of the members of the administrative board, which necessarily consists of religious ministers of its members, are attached in the request. The provisions in force for the religious legal persons apply accordingly to the church. The indication ecclesiastical legal person shall be included in the name. In the Article 12, in the beginning, a definition of the term church is given. Church is a union of almost 3 religious legal persons of the same religion, which have an episcopal or synodical structure, or any other central structure. It functions according to its statutes, and it is managed by elected or appointed individual or collective organs. So the founder members must be at least 3 religious legal persons. That is, The founder members are not natural persons, but only legal persons of the type of religious legal persons. But these religious legal persons must belong to the same religion. If we see the organization and administration of the religion concerned, it can be episcopal or synodical or any other central structure. So we can conclude that all types of policy are accepted under this phrase, with episcopal or council structure or any other central structure. And that is concerns the administration all the type of administrations are accepted because it is written by elected or appointed individual or collective bodies, organs. Then, in the second verset of the Article 12, it is stated that the founder members, which are religious legal persons, must submit a joint application to the first instance court of the seat of the church in order to acquire a legal personality through its registration in the special register kept in the court. Then, in the third verset, the documents accompanying the application for registration of the ecclesiastical legal person are enumerated. First, the instrument of incorporation, as it happens with the religious legal person and the common associations, each statutes the same. The confession of faith of the three religious persons, this is a special requirement for the ecclesiastical legal person, as it was a similar one to the religious legal person. And the names of the members of the administration, which necessarily consist of religious ministers, of its members, and the list of the names of the members of the provisory administrative organ, has to be attached also to the application for registration of the ecclesiastical legal person. The names of the members of the administration must contain names of religious ministers, of its members, necessarily as it is referred to. As it concerns the other matters of the procedure, the provisions in force for the religious legal persons apply accordingly to the Church. It is specified also that the indication ecclesiastical legal person shall be included in the name, for example, Buddhist Union of Greece, ecclesiastical legal person. But because the time passes, we have finished our 11th lecture and will continue explaining the Article 12 in the 12th lecture. Thank you for your attention.